واليوم يا ربي أعود من ظلمة خلف الحدود فالقلب منكسر وطرفي حائر وأنا الغريق فلا أرى إلا سواك لمنقذا لا منجى ولا منجى إلا أنت يا إلهي 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 يا إلهي.
Assalamu alaikum. Peace be with you, all of you. So I'm honored to speak today at this lecture series, which is named after my very good friend, Dr. Taha Jaber Al-Alwani, whom I miss and hope to see very soon. So let me start by addressing an often repeated statement, namely that Islamic Sharia deals with all aspects of human life. You've heard Muslims say it, and you've heard non-Muslims repeat it. This statement is usually made to bolster two related claims. First, that this description is unique to Islamic Sharia. And second, that Islamic Sharia is bound to clash with the laws of a secular or non-Muslim country, because it deals with everything. It covers a lot of ground. And I would like to argue that both claims are false. The Islamic Sharia is no different in its pervasiveness in our lives and the lives of its followers than Christian or Jewish Sharia. And by the way, you might be surprised I'm calling it Christian Sharia or Jewish Sharia, but really Sharia means body of law. In Arabic we say Christian Sharia. There's nothing fancy there. For example, and you made my task much easier, thank you. Christian Sharia sets rules for commercial transactions. That's not the personal part of your life, that's the public square. For example, the prohibition of usury, right? And this, by the way, explains our legal aversion in this country to windfall profits. Where did that come from? If it didn't come from those ethical values that we derived from our religions. It also addresses, the Christian religion, various aspects of marital life in some detail, and these details vary among the sects. Jewish Sharia also addresses a broad range of issues of its followers. And as a matter of fact, because of that, it had needed to establish Beit Dins, for those of you who are familiar with them, in the US, which are religious courts that rule on matters that range from the personal also to the commercial, because they come under the umbrella of religious ethics and law. So what is different about Islamic Sharia is not its pervasiveness in the lives of Muslims. I've just argued that all three heavenly religions are just as pervasive. Whether you follow them or not, that's another matter. What's different is the view that Islamic Sharia is different. That's what's different about it. Perhaps even strange. A fact that makes its pervasiveness much more noticeable in society, a society which is more tolerant of Judeo-Christian traditions and is alarmed by seeing something different, or at least something that it perceives as different. You know, we talk about hijab, covering your hair, but some Jewish women cover their hair too. That's not strange. That's not different. Why all this focus? I think that was part of my gripe. So this fact about feeling uncomfortable about a strange religion is rendered more glaring as a result of recent waves of Muslim immigrants from war-torn countries and areas of conflict. These immigrants are still in the process of adjusting to the U.S. cultural and constitutional values. So maybe that's what we are feeling, not something that is religious. We'll talk about it a little bit more. Incidentally, this problem of being new immigrants is further complicated by the fact that many of these immigrants come from lands that were not ruled democratically. And again, that's not part of the religion. And if you want to understand why, please go to Karama's website and my articles on democracy being at the heart of Islamic governance. So because these people came from lands that were not democratically governed, that meant that they were not familiar with the various democratic tools for advocating and bringing about change. This is actually, we take it for granted. I take it for granted. I was born in Lebanon. I was used to all of this. You take it for granted because you were born in the U.S. and, many of you, and you know how to do it. But it's a skill. It's an art, how to use the various tools available to you to peacefully change society. So consequently, those new immigrants may feel oppressed or frustrated by their surroundings and not know how to change them. Which is why one of the things Karama is seriously considering is going around the country to the communities and giving constitutional law education. So they may even distrust the voting process because of lack of knowledge and familiarity with it. An immigrant imam, for example, may announce to the community that voting in a secular state is prohibited by the religion, right? You've heard such things. No? I've heard other things too. Most immigrant Muslims do not have sophisticated knowledge of their religion. That's another important part. We need to educate Muslims about their religion, the true principles of their religion. And so such erroneous statements may have some effect on them when somebody tells them, oh, this is a secular system, don't participate. Indeed, in prior decades, many Muslims did not even allow their children to attend law school for such reasons. I would get calls from children saying, please talk to my parent. They don't want me to go to law school because the imam told them that this is a secular system and we should not participate in it. So I remember in the 1990s, now I'm dating myself, lecturing in mosques and Islamic centers around the country in which I begged the families, this was my argument. Muslims love to educate their children to be doctors, right? Every other person is a doctor in the Muslim community. So I said, I remember using the following language: would you kindly sacrifice your second child to law? Now today, it's a different world. There are many Muslim lawyers and law students who are active participants in the profession, especially the civil rights movement. You hear their voices. They have made, put together organizations. Some have also run for office, worked on the Hill, clerked in U.S. courts. So that kind of worry is behind us. That kind of history is behind us. So the adjustment process and the mainstreaming of American Muslims is happening, is going on right now. In fact, we are in the middle of it all. And a couple of decades from now, Americans will find it strange that such questions about the compatibility of Islamic Sharia and American law even arose as an issue. This is especially true given Islam's clear similarity to Christianity and Judaism. to American religions, if I may call them that, they are also world religions, whose compatibility with American culture and values were not similarly questioned. I also have a feeling that as time proceeds and we become more comfortable with each other, and Muslims become more comfortable with the culture and the knowledge base in this country, that they will follow up on my research on Jefferson and the Founding Fathers, and my attempt to find out how much knowledge did the Founding Fathers have of Islamic law. We already know that they studied Islamic cultures. You can find that in the federal debates. You can also find it in Jefferson's letters and in the fact that he possessed a Quran, at least one, maybe two, which is now in the Library of Congress. The fact that he uses language in his encyclopedia that there is no compulsion in religion, which is what the Quran says about freedom of religion. Is there an Islamic history to this country which has not been explored yet because of the fear of the other, and because the other who's now looking at it is either a new immigrant who is not rooted in this country, or newly liberated African Americans who came to this country through another route and another experience? I think that's a very important part of American future studies that need to go on, and I could talk more about it if you'd like to know during Q&A. There is, of course, another major reason for the questions that are being raised, namely that there has been a significant otherization and negative stereotyping of Muslims in our American culture. This has become especially true after the 9/11 disaster. Before then, I remember participating in a lot of interfaith meetings, press conferences, etc. Our relations were advancing very nicely together, and Muslim scholars and activists were welcome to the national table. There was not a problem, not much of a problem. After 9/11, a barrage of negative stereotyping blanketed the country, and average Americans began to view Muslims as terrorists. Now, of course, I'm talking generally. I am aware of those communities of non-Muslims who protected the Muslims in the community by, for example, creating a human chain around the mosque so that no one would attack it. These are stories that we will proudly tell to our children and grandchildren about the American people. Yet, we cannot ignore that there is a real barrage of information, false information, misinformation, which stereotypes Muslims as terrorists. This was quite a serious development that Muslims have lived with for the last decade. While more reasonable voices are emerging today, we need to focus on a very important phenomenon which is happening to our new generation, the generation of our children. Muslim children at this very moment are being bullied in their schools and called terrorists, a situation which has caused them serious emotional distress and damage. I was just reading a report by a Karama person who reports, we meet with the Department of Justice routinely along with other people of faith and bring up issues, and I was reading her statement, and in which she speaks about a meeting in which 20 children were brought together and asked, how many of you have been called terrorists? No, how many of you have been criticized? And they said, do you mean terrorists? And then the teacher said, yes, and every single one raised their hand. Every single one. What's worse than that? These children no longer complain to school officials because they do not believe that such complaints would make a difference. And sometimes they don't even tell their parents in order not to stress their parents. This is not America. This is not what we do in America. And this needs to change by shining the light on it. And therefore, loose words are not insignificant. Hate language has effect and consequences, and it's influencing and affecting and stressing our children. Complicating this already complicated picture is the fact that immigrant Muslims tend to be traditional and, may I say, patriarchal. How many Muslims do we have here? Never mind, I'm not going to question you. I already know. By the way, that's why I like Dr. Taha, because he always understood these issues. And he was very supportive of my work and other women. The more egalitarian approach of our society disturbs and confuses many of these patriarchal men. Some even live in denial. This is the case of the Moroccan immigrant in New Jersey. I don't know if you've heard that story. He severely abused his wife and ended up in court. He's an American, or resided in America, I'm not sure which, but when he was ready to marry, he decided to go to Morocco and get a wife from the old country, and then imprisoned her in his home and abused her physically, continuously, drove her crazy. And so at the first opportunity she could find to go out into the street, she did. And some women found her in that horrible state and discovered what was happening to her, and they helped her. And she went to court. The husband, in his defense, was backed by an imam who testified as an expert witness. Why do we need an expert witness? Because the court cannot involve itself in religious issues. So the judge cannot decide to go to IIIT and look at the library and find out what does a certain concept mean. But he can, and neither can he ask the clerk to do that. But he can ask for an expert testimony. And so who testifies becomes very critical, and unfortunately that has been not properly regulated within the Muslim community. Sometimes when a judge hears that an imam is an expert witness, the judge immediately concludes that that must be a qualified person. He's an imam. No, an imam leads prayers. He knows the Quran by heart. He might not know the fiqh, the jurisprudence, and he might not know the subtle points that arise in the court case. So this imam testified erroneously that the husband's behavior with his wife was religiously sanctioned. So that the husband thought he was not doing anything wrong. That was okay. God allowed me to do it. And so the judge, bowing to culture and this argument, ruled in favor of the husband. And guess who got mad most of all? Muslims. Not just Muslim women, Muslims, right? Because he was clearly in error. We do not want to defend men who engage in poor behavior. Well, fortunately, we have a system which has checks and balances. So this court decision, verdict, went on appeal, and it was reversed as it should have been. But it was that incident that started the anti-Sharia movement across the country. And it spawned many unconstitutional or redundant statutes. Unconstitutional, you've certainly clarified that in your speech and in your example about Oklahoma. And by the way, I do want to say one story about the Oklahoman experience. I was in a neighboring state giving a lecture to the Muslim community. And one person came to me and said, Professor Al Hibri, our women are really scared from the legislation. And I said, why? He said, well, they think that if a muhajjaba, a woman who covers her hair, goes down the street and is stopped by a policeman, and he asks her, why do you cover your hair? And she said, because I follow Sharia. Well, that's prohibited by the statute, and he's going to jail her. And then he said something that made me very, very, very sad. He said, so the women I was talking to told me that if they are ever stopped on the street by a policeman and asked why do they cover their hair, they will say, oh, because I have a skin disease. That in America, which has a First Amendment, that's what's happening to the Muslim community and to the poor Muslim women who were scared about what they heard. That is not who we are. And that has to stop. What is, I find, more important about the anti-Sharia legislation, because as we know, when it went to court, it was found unconstitutional, is that it, instead of allowing Muslim leaders to use their time to build the community and educate it, they were spinning their wheels, trying to tell everybody around the country that these anti-Sharia proposed statutes contained a lot of misinformation and were bad for not only Muslims but for the country. At the same time, the anti-Sharia movement succeeded in bolstering in the minds of the American population the otherness of Islamic Sharia. It's something we have to stop. Have we ever heard of anti-Sharia movement for another religion? No, but this one is dangerous. This one we have to stop. It's dangerous to the American system. The poor American worker, we're all workers, by the way, we work very hard. We were just talking about how much time emails now have taken from our lives, and we've become really slaves to the emails. We all work very hard. How many of us have time to go and research many of these claims and find out what is true and what is false? Yet in our minds, we start developing this notion of otherness, dangerous religion, connected with the notion of terrorists. And for me, it's sort of hard to argue. In fact, in something I've been writing, I've argued the following, that in the end, when all of society is imbued with this prejudice towards Muslims, unconsciously, it sort of seeps unconsciously into our thinking because of TV, watching TV when you're ready to sleep, watching it when you're awake, reading the papers. It must also affect judges, legislators, and many others subconsciously as well. And that really complicates the problem quite a bit. The laws that try to tell us that foreign laws should not come into our courts because American law is supreme, guess what? We know American law is supreme. We don't need a legislation to tell us that American law is supreme in our courts. That is a given, a legal given. Okay? It's the law of the land. There is no danger of the law of the land being trumped by any other body of law, not even the law of the EU, speaking of cultures that are not other. When other laws are recognized in our American courts, it is due to various considerations within our established legal system. It's nothing new. For example, comity. If they recognize us in other courts in this situation, we'll recognize them in our courts in this situation. That's what comity means. Or the law of contract. You know, we have freedom of contract in this country, and you could choose the law of any state or land you please. You know, you're doing a deal with a Japanese company. You could choose Japanese law. So if there is a contractual problem, you want the citizen to go to Japan to adjudicate it because you cannot consider Japanese law in American court. That is a big disadvantage to American business. And by the way, American business understood that. And in some of these anti-Sharia statutes, they had an exclusion, a carve-out for American business. Islamic law, as you had observed, come mostly into American courts through divorce cases. Since these cases usually involve the marriage contract, then the law of contracts comes in, and the contract is examined by the court to determine its provisions. Usually, the contract includes the notion of mahr, which also has, there are other words that we use for the same concept. But I wouldn't use dowry, by the way. I do want to say that, because dowry seems to have a heritage of meaning that is contrary to the Islamic meaning. The notion of mahr is really a marital gift, just like in the West you give a diamond ring. It doesn't have to be material, by the way. But it's a marital gift with which the judges are not familiar. They don't know that notion. Usually for financial reasons, if a young guy is getting married, he'll say, okay, I'll give you an advance now on the marital gift, but the real big stuff, I'll give it to you if I die or we divorce. I'm going to medical school and I'm going to be very rich, so the deferred stuff could be $1 million. If you want to do it all now, you'll get $10. So people have figured out culturally that kind of solution, which our judges don't know about. So to understand that notion, they turn to experts who unfortunately sometimes, again, don't give us the right testimony. Men in divorce cases tend to have more money than women. They therefore tend to get expert witnesses to the judge when women either can't or cannot choose as well as their husbands can. And men usually bring testimony of an expert testimony that is going to support them, so that the judge would say, okay, you don't have to pay the delayed $1 million or $50,000 or $5,000 mahr. Okay? Sometimes expert testimony has misled the court. I've been following all those cases. Sometimes the testimony was incomplete, changing the results, which led me to question, whether the expert knew which law actually applies to the situation, as opposed to the law he described to the judge. But the upshot of all this is that when past testimony, I know I am thinking of one in particular in Virginia, because I used to teach in Richmond. I'm still Professor Emerita, but I got a lot of phone calls while I was there. But there, in one of the jurisdictions there, somebody came to the judge and described the mahr to him in a closed testimony. Because it is a family case, they do not open the case unless both parties agree, and they don't want to open it, at least one party. This expert testimony said something about mahr, which led the judge to say, I will not enforce that provision because it is against the public policy of the Commonwealth of Virginia. Now, I've done a little bit of sleuthing to find out what kind of testimony might have been given, what kind of content. I knew who the expert witness was, so I researched his views, and I found out that in his views, mahr was bride price. Bride price? Islam came precisely to stop the Jahiliyyah habit of fathers selling their daughters, and made it mandated that if there is a monetary gift or any other gift, it will go to the woman herself and not to her family. It's a gift to the woman. But if a judge hears that testimony, do you blame him for saying, oh, we cannot enforce Islamic law because it is against the public policy of Virginia, of the Commonwealth? So here are some of the issues that we are facing. And we do it because somebody wants to avoid paying a certain amount of mahr to his wife, so he allows the whole community to suffer from a bad precedent. And I've told them that at times. I remember sitting with some of them and talking to them about this. And I said, do you realize that this bad precedent is going to haunt your daughters? Is going to haunt your sisters? You might have gotten out of unfortunately gotten out of payment of mahr to your wife, but you've hurt all the women in your family down the line. And you did it wrongfully. When the judge received proper definition of mahr from an expert testimony, the judge enforced American contract law. There was no problem. And one leading case is in New Jersey, and the lawyer who actually defended and explained what mahr is to the judge is right now speaking at Howard University at a Karama function on Islamic law and American law.
You converted him.
Huh?
You converted him?
Yeah, the judge bought the argument, and it really established a very positive precedent for other circuits in the area. So, what the example I gave you shows is not the otherness of Islamic Sharia, but rather the lack of knowledge of Islamic law among most American Muslims and the absence of scholarly Muslim institutions that can fairly arbitrate and resolve problems within the community or even provide reliable expert testimony to the courts. There is a real need for Muslims to have their own bed-deens. Parties could choose to subject themselves to the jurisdiction of these arbitration bodies, whose judgments are then enforced by our court system. Any party may refuse to go to these Muslim bed-deens and opt instead to use the court system of this country, so it is voluntary. But the existence of these bed-deens would eliminate the need for expert testimony that could misinform the judge and create bad precedent, because the people sitting in bed-deen know exactly what the religion says. Nevertheless, this is not yet a call by me for establishing Muslim bed-deens, simply because as a prerequisite to this step is the graduation of a class of potential arbitrators who are unburdened by patriarchal cultural interpretations of religion that discriminate against women. So we're working at on that at Karama. So this leads me to the final element I would like to mention in the process of othering Islamic Sharia, namely the misguided understanding of many Muslims of their Sharia and confusing it with their cultural practices and values, some of which are highly reprehensible. And let me be clear. In Islam, rape is a crime against the woman. You don't punish the victim. Some countries have been punishing the raped woman and letting the rapist go. That's not Islam. I don't know what it is, but I know for a fact it's not Islam. In Islam, there is no such thing as honor killing. Killing is dishonorable. A husband who accuses his wife of being with another man must take the matter to court. The wife will have equal opportunity to deny the charges, and the case will end in divorce, not death. Domestic violence is not okay. A woman may divorce her husband if he abuses her, even verbally. Witness the laws of Jordan and Kuwait. It's right now in their family code. A Muslim woman has a right to divorce similar to that of the man. Believe me, many women don't know that. It is called khula. We introduced it in this country. In the sense that we informed women about it and found imams who would actually give khula. A Muslim woman is fully entitled to education. She is also entitled to work and to have full control over her finances. All of this is detailed in articles on our website. A Muslim woman may not be forced into marriage. Her free consent is essential to the validity of the marriage contract itself. And in the marriage contract, she could describe with her husband the kind of marriage relationship they want. She could say right from the beginning, I want to be a stay-home mom. I want to be a career woman. I want to go to school and get my PhD. She would specify all those as conditions of marriage. Once married, She's not obligated to do housework. Muslim women have applauded me for saying that at lectures. They don't know that. Also, by the way, she's not obligated to nurse her child unless the child refuses any other source of nourishment. And I could go on and on and on. I bet you didn't know many of these rights. But few Muslim men and women know all that. And part what Karama does is to go around and tell them, yes, this is your religion. So this is why we American Muslims have a world-class opportunity now to lead Muslims worldwide. Because they don't know. Many of them don't know. Look what's happening in Afghanistan. They're being told women cannot go to school, and if they go to school, they get shot. When the Prophet himself said that seeking knowledge is the duty of every Muslim and Muslimah, Muslim, male or female. What are they reading? Those who prevent women from education. So this is our opportunity to develop an Islamic jurisprudence that is truly Islamic. We go back to the roots. Yet suitable for a modern society like ours and other modern societies, and suitable for the 21st century. You might think this is a radical call for change. It's not. Over the centuries, jurists have agreed on the major principle that derivative Islamic laws change with time and place. And so for each time and place, you need a new jurisprudence that matches the needs of those people. Because God, the lawmaker, promulgated the law in the interest of the people. So if a law changes because of a change in time or place and ends up hurting people, you can suspend it. And if a Q&A, if you want examples of that, I'm more than happy to give you. We can bring to the fore previously neglected aspects of the prophetic model. For example, 2 days ago I was lecturing in an Islamic grouping, 700 people in the audience. I said, you need a 21st century leader, model. Somebody who is really hip to the issues of today. Don't look at yesterday. Look at what we have today. Conflict resolution, women's rights, even animal rights and environmental concerns. And then I brought a whole list of examples from the Prophet dealing with these issues that they did not even know about. Because people who are focusing on the prophetic tradition are focusing on something that served them in a different society and a different time. We can break away from oppressive past cultural customs. And we can enjoy our presence in this land by rediscovering Islam as the modern religion it really is. That's our work at Karama. And if we are told that Islam and democracy are incompatible, or that Islam is a theocracy, and thus conflicts with the basic constitutional principles of this country, which involve separation of church and state, I will simply refer them to my articles on these matters on Karama's website, which I wrote at least 20 years ago, and I'm not sure why people keep asking this question and trying to answer it. I thought I did that already. So at this point, I want to close with the following remark. And thank you for being so patient with my talk. Muslims have been in America even before the United States was born. People forget that. They think of new immigrants. That's not true. We have helped build this country. We helped birth its civil rights movement. We built the country in the South on plantations, in the North in factories, and we helped birth the civil rights movement. We are doctors, lawyers, businessmen and women, engineers and professors, to mention a few things we do. We shall continue in our efforts. And as to the attempt to otherize us, I have a simple American answer for you. We shall overcome. Thank you.
you said that you knew about the image of the Prophet Muhammad that is found at the Supreme Court of the United States. I've not been able to get there to see it. I'd like to know which building I go to and why it's there.
Actually, I'll tell you that story. And maybe now that time has passed, I could write the story and put it on our website with the documentation without mentioning the names of the other parties, because I don't like to point the finger at anybody. I just want to say what we did. But at one point, very early on in the history of Karama, we decided to familiarize the Muslim community with constitutional issues, especially freedom of religion. And what better thing to do than to ask them to come to the Supreme Court and listen to some comments by Justice Scalia, whom I had met at the Jewish Theological Seminary, and he was kind enough to say, okay, I'll give those comments. At that time, if you don't mind me telling the full story, the Muslims did not have a building like this one. And I told that to Justice Scalia, and he said, come to the Supreme Court. There's a room there, and we can do the event there. My brother, may God rest his soul in peace, heard that story and purchased this building so that Muslims would have a place to give lectures. So it's all tied together. So we went to the room, and there was an appellate court judge from Virginia who gave remarks, and then Justice Scalia gave remarks. And we told the people, there were like 50 Muslims from all over the country, go around, look at the Supreme Court room, familiarize yourself with this setup. So they did. Everything went very nice. I got some very nice notes from everybody, and I was very happy. And then I think it was late December or early January of that year, I get a call from the clerk of the court. No, I get a call from the organization whose name shall remain unnamed, saying, we'd like you to join us in our action against the Supreme Court. I said, what action? I'm a lawyer. That's my Supreme Court. Nobody is going to tell me you're going to take an action against it. So I said, what action? And they said, well, there is a statue of the Prophet Muhammad in the courtroom itself. And as you know, that is haram, prohibited. This is a good story. It brings up a lot of the people we need to hear about. And so we think, we have contacted the Supreme Court and told them that they need to sandblast it because it's haram, prohibited under Islamic law. And I said, first of all, are you sure? I've never thought that the Prophet's image would be in the Supreme Courtroom. That was a big shocker for me to start with. They said, yes, we've established that. That's not an issue. I said, okay. And so you want it sandblasted? They said, yes, and we've told the court we'll take action, demonstrate, I don't know what, down the street, if they don't sandblast it. I said, who are you talking to? They told me. I said, let me think about it. And I called that person, who is not a justice, somebody in the administration. And he was initially cool to my call, but then he found out I'm a professor, and then we had a nice conversation. And I said, what's going on? And he was very disturbed about the approach that this group has taken towards the Supreme Court. They didn't understand what the Supreme Court means to us, okay? So maybe they thought it's another Safeway and you can boycott it. I don't know. So I said, is it true? And he said, yes, there is that, and you can come and see it. It's a frieze. It's not a statue. There's a difference. It's not a statue. It's a frieze. Well, then I'm not so clear that it is haram. And I was worried that the Muslims would take an action that would be terrible with respect to the Supreme Court. It was my Supreme Court, and I was going to protect it. That's how I felt, very personal about it. So what I did, I thought, I know that my instincts on this are right, that Islam does not say it's haram. So I talked to these people, and I found out they had other incentives for escalating the case, which I will leave unmentioned. So at that point, I realized that I have to protect the Muslims as well from this approach, and not just the Supreme Court. And I turned to Dr. Taha, your father. And I said, Dr. Taha, this is not haram, is it? And he said, no. I said, I need a quick fatwa. Because these Muslims are being told, who don't know their religion, they're being told that the Supreme Court somehow is denigrating the Prophet by having him on the fringe. And they're hurt. So you need to give me a fatwa really quickly. And he said, this is a frieze, it's not a statue, da-da-da-da. He wrote a very quick fatwa of a few pages. I think I still have it. He faxed it to me. And then I asked him for a more longer fatwa, which probably is the one you got, which I published in the Journal of Law and Religion. And we gave it at that time, gave a copy to Justice Rehnquist so that he knows what Islamic law says about these issues. I also I thought Dr. Taha is a Sunni, I need a Shia. I turned to Sayyid Hussein Nasr, and he also gave me a fatwa. Armed with these two fatwas, it was my spring vacation, or else nothing would have worked. I called for meetings around the country and traveled. And I remember I was even in Chicago, talked to leaders of Muslim communities, and I said, here's a press release of ours which says it's okay. Because they have already issued a press release that was very insightful to problems. So many leaders, after they saw the fatwas and heard my remarks, signed the press release. So at one point, it was a stalemate. I had as many as they did. The Muslim community was totally split in half. They didn't know whom to believe. And one large organization signed both. And we had to act quickly because you have to imagine, I'm a single woman faced with a patriarchal society and patriarchal organizations, and I'm fighting. And who supported me? Your dad, Sayyid Hussein Nasr, and a wonderful guy in Chicago, Indo-Pakistani background, who's now passed away. And so I said, okay, what am I going to do? And in Richmond was the daughter of W.D. Muhammad. And we were both being interviewed for a book, so I was in touch with her, and I told her the story. Her husband was an imam. She told her father. He called me at midnight from Chicago. He said, I'm with you. I don't like this other stuff. I said, what can I do for you? I said, you need to sign my press release. He said, okay, I need to be near a fax machine. In 1 hour, I will be there. I'm traveling to a fax machine just to sign what you need. I waited. In an hour, I faxed it. I got the signature back. And the next day, the whole storm died. Nobody wanted to go against W.D. Muhammad. That's the story.
The law of religious communities and the law of the land is our topic for this evening. And the main thing that qualifies me to discuss this challenge of people who face, who live under two simultaneous bodies of law, religious and civil, is this. I reside inside the boundaries of Fairfax County, Virginia. But the Postal Service designates my address as Alexandria, Virginia, which is not part of Fairfax County, Virginia. Two descriptions by two authorities, but one man living in the self-same house. So far, no one has cited me for intentional misinformation. Scholars of law have labored long with overlapping jurisdictions and simultaneous belongings. Jesus of Nazareth was once asked, it was really a test. Some of his fellow Jews living in the Syrian province of the Roman Empire said, "Is it lawful for us to pay taxes to Caesar?" And he replied, "Show me the coin. whose likeness is on the coin? They said to him, Caesar's. And he said, then give Caesar what is his, and give God what is his. And as Christians today ponder these issues of the public and the private realms, we continue to ask ourselves, what did Jesus mean? Conflicts can arise between the law of the land in the United States and the laws of particular religious communities. I'll just recall for you a few past instances. Christian pacifists, including Brethren, Quakers, refused to obey the law requiring men of a certain age to register for the draft. Eventually the law was modified to allow conscientious objectors to war, to perform alternate service. The Jehovah's Witnesses have resisted in court and insisted they will not pledge allegiance to the flag of the United States. Christian priests have claimed immunity from giving testimony in court about what they've heard from penitents who were privately confessing their sins. Christian law of marriage, Islamic law of divorce. I don't speak about Mormon law, which originally sanctioned polygamous marriage and then had to conform for Utah to be admitted into the United States. All of these situations where religious law and state law prescribe our conduct, but the prescriptions don't agree. What do we say to them? Is it self-evident that state law will prevail because we wish to be one people living at peace under one law and the state has the coercive power? Or is it possible that the state in our day is in such need of legitimation and loyalty that the state needs to listen again to the sources of authority that are known to the religions? Now, I'm not sure I'm the one to suggest that the state might lack wisdom and legitimacy. I'm a happy citizen of the United States. I belong to the numerically and historically dominant religious group. I'm heir to a 2,000-year Christian tradition that contributed some of the concepts, some of the procedures to the law of the land. I'm not a student of civil law. I am a respecter and a student of Islam. And I particularly respect the labor of Dr. Azizah Al Hibri and her associates in Karama and other leaders of Islamic societies and communities in this country as they've resisted unwarranted attacks arising from irrational fears. It's funny, these attacks, some of them seek to enlist state power, and they profess to aim at heading off a movement to insert coercive Islamic law into the law of the land. They want power to defend them from power. I consider the anti-Sharia law movement foolish, unhelpful to our common life in the United States. I hope it will fizzle and evaporate. But still, I think we should take a look, and Dr. Al Hibri will take a better look at the instance of Islamic law in the United States as it's actually encountered and been factored into the law of the land. Some places where Islamic law is rubbed up against constitutional law and law of contracts. Let me start with the famous Oklahoma constitutional amendment that failed. It was 2010. The legislature of the state of Oklahoma recommended that voters adopt an amendment to their constitution. There was a lot of publicity during this election. And finally, the measure received the approval of 70% of those voting. The thrust of this amendment was to forbid state judges to consider foreign or Sharia law. State judges forbidden to consider foreign or Sharia law when any case was before them that they were deciding. A state senator named Anthony Sykes was the sponsor of this constitutional amendment, and he was quoted as explaining that its intention was to ban courts from considering all religious laws, and Sharia was just offered as an example. This Oklahoma amendment to the Constitution understandably produced alarm among Muslims as a precursor of future mistreatment. Not sure of the position of the plaintiff named Awad. I think he was the Oklahoma City chairman for the Council on American Islamic Relations. He brought suit, asking relief. And here are the harms that he claimed he would suffer if this constitutional amendment were allowed to go forward. He said his religion was singled out for negative treatment. The amendment stigmatized him and other Muslims. It disabled a probate court from probating his last will and testament because it has references in it to Sharia law. He said it would limit the relief Muslims can obtain from Oklahoma state courts, and it fostered excessive entanglement between the government and his religion. The Attorney General of the United States promptly announced that he would challenge the Oklahoma Act as contrary to the U.S. Constitution. And sure enough, in January 2011, the U.S. 10th Circuit Court of Appeals affirmed a circuit court finding that it prevented the Oklahoma Amendment from taking effect. Two elements caught my attention in this case. One, I hear an interesting contradiction between two of the harms that Mr. Awad said he was seeking relief from. One harm was excessive entanglement between the government and his religion. The other was limiting judicial relief that he might in the future wish to seek from Oklahoma courts. Maybe that's commonplace in lawsuits. Maybe you list a whole lot of harms and you hope that the judge will acknowledge at least one of them. But is it also possible that there was a very human ambivalence on the part of Mr. Awad, as in the broader Muslim community, on the one hand desiring to be left alone, and on the other desiring to have the government on our side when we need it? I'm also intrigued in the decision how much the court's decision turned on this word other. It's in the act that was passed by the Oklahoma legislature. The proposed constitutional amendment would have prohibited courts from looking to the precepts of other nations or cultures. And then it went on to add, and specifically international and Sharia law. The appeals court noticed this word other. They said it implied that any cultures, including religions, which the legislature considered to be part of domestic culture or Oklahoma culture, would not have their legal precepts excluded. Only other cultures would have their legal precepts prohibited. So the appeals judges reasoned on the basis of grammar. They said, you speak of other nations, other cultures, that inherently means distinguishing them from a known, near, local, prevailing culture or nation. Other implies outside, over there, not near at hand, not mine but theirs, not ours but yours. I speculate that the judge's sensitivity to this modest word, other, was probably heightened by a whole generation of social science theory about the self that defines itself in relation to others. I certainly know that othering has entered the vocabulary of preachers and champions of diversity in places where I live. I take it othering is now considered a wrongful act. And this question of identity, it's big. Am I who others say I am? Or am I who God says I am? And I think we have to ask a parallel question about the law of the land that demands our loyalty. The judges dispensed with this amendment very quickly. They said it fails to treat religions neutrally, so it fails the clearest command of the Establishment Clause: Congress shall make no law concerning an establishment of religion, and neither can Oklahoma. So they dispatched it very quickly. But I think we need to linger a little longer on what's really been the experience of Islamic law in our courts, and then come back to law of the land. As I said, the anti-Sharia campaigners were playing on irrational fears led by headlines, fed by headlines about revolutionary movements elsewhere, punishments by stoning elsewhere in the world. I've not heard of any institution created by immigrant Muslims in this country who dream of an autonomous Islamic state operating within the United States. All of the Muslim schools, student associations, mosques, businesses, professional associations, trusts, relief agencies that I have any inkling of, the Muslim affiliates of national youth organizations or sports leagues that I've heard of, they might need a little legal recognition as corporations, as charitable institutions, but they have not been seeking governmental support, much less coercive powers. As far as I know, the big movement for charter schools does not, privately managed, publicly funded, does not include any that teach the precepts of a religion. So the question of funding for Islamic schools, I don't think arises. But the one area of life where Muslims have turned to the courts for enforcement and definition and resolution is the area of marriage law. The scholars of Karama have compiled a really interesting collection of cases going back decades in which state courts have looked at premarital contracts or a divorce decree or a marriage record that was issued by an Islamic authority. And on these occasions, the state court then had to decide to refuse to consider it the way the Oklahoma commandment or amendment would have required. Courts already could refuse, or they could decide to enforce what's brought to them, or they could decide to interpret it, take on to themselves to say what the terms of that document, although couched in Islamic concepts, what it meant. Some of these cases have been very international. A case decided in Maryland by the highest court had to do with a marriage contracted in Karachi and divorce granted by Maryland court. So it was an international case, and it was a big money case. $1 million pension of a World Bank employee was at stake, and he was seeking to put it out of reach of the wife who'd received the divorce in Maryland court by taking it instead to Islamic arbitration. I think it's called Court of Arbitration in Pakistan. He said they had jurisdiction because that's where the marriage was contracted. Not all cases are international, though. In my Fairfax County, that doesn't quite know whether I belong in or not, in 2006, they had a suit for divorce that required them simply to consider an Islamic marriage contract made in Virginia. No international element to it at all. And the question turned on the payment dates for dowry, the early provisional dowry and the later, more substantial portion that comes into play at death or divorce. And one party to this divorce objected. The court should not enforce it because the marriage contract was vague about the dates for payment. And the court said, no, this contract is not void by reason of vagueness. They knew what to do with that Islamic marriage contract. Plenty of others. The late Sharif al-Khatib has noticed that more and more Muslims contracting marriage here do want to write a contract, and they write into it provisions having to do with who may initiate the divorce, dates for payment of this dowry that was disputed in the case I mentioned, conditions like renouncing the right to take a second wife, where shall the place of residence be, work outside the home, all those can be written in. And increasingly, Muslims contracting marriage in this country know to make sure that this marriage will be recognized without question by courts, by getting a marriage license, having the officiating person be someone who is recognized by the courts as having that authority. And in the future, it's clear that second generation and Native American Muslims numbers continue to grow. The courts are going to see more and more cases where all of the marital life that's considered in a divorce case took place in the United States. So international comity, recognition of other bodies of law is not going to be the case. But I'm not just interested in this level of details, levels of post-divorce spousal support, standards of decorum, definitions of modesty, all those details very interesting and important to people living out their lives, but I'm more interested in, is there divergence at the level of the foundations of the two bodies of law that we're talking about? Law is related to ethics. Ethics underlies law. And matters that may or may not reach legislation, may or may not reach adjudication in courts, we want to get it right, and so in our individual communities we work on our ethics below the level of law. And Dr. Al Hibri represents a body of people who've worked with great intercultural sensitivity to work on these jigsaw puzzles of intermeshing the law, and enforcement, and application. But behind all these questions of application, there is the question of the source of the law that we want to honor. Shafi'i may have been wise. Faruqi may have been creative. My sometime co-teacher, Dr. Muhammad Adam al-Sheikh, may be proficient at guiding people through the territory that he says is still left open to him by American civil courts. And the 10th Circuit Court may have had wise judges. But when the law makes a decision that denies some party what they thought was their due, won't they talk back and say, who says so? And even if they just mutter, who says so? Aren't they asking not just who says that's the law, but they're also asking where did this law come from? And that gets close to the question of Is the law true? It's a rather impertinent thing for me to ask. Is the law true? And yet, if we are the ones to be guided by law, I think we then do dare ask. If the law is to be our guide, we have to know that it's a guide we can trust. I'm going to Istanbul with Sayılgan in June because I trust him. You want a guide you can trust. He knows the city. I've never been there. I'll go with him because I trust him. Is the law a guide that we can trust? And the state that enforces the law, it'll have legitimacy in the eyes of its citizens if they trust the origin of its law. So I'm not now talking about, obviously first I'm not talking about idolatry. I don't think Jews or Muslims or Christians are likely to mistake the state for God. But we do believe that the state and the state laws we submit to should be from God or of God, or at least agreeable to God. So I'm now talking not at the overt, explicit level of applications, but I'm talking down at the level of the foundations. I'm not talking about building permits and prenuptial contracts, but I'm talking about the presuppositions of the law. The ones we don't usually talk about. They're out of sight. And yet, at this deep level of unspoken presuppositions, everything we think we know about the nature of God and the purpose of God in this world has some bearing on whether law is rightful, authoritative, that the state seeks to enforce. Taha Jabir al-Alwani, for whom this series of lectures is named, and other scholars now associated with the International Institute of Islamic Thought, based in London and Herndon, Virginia, they've been asking themselves a lot about purposes of the law. God, who is compassionate, intends mercy, and He provides guidance to His world. And so the laws that can be deduced from Quran and Sunnah are not whims. They have purpose. Muhammad Hashim Kamali of the International Islamic University of Malaysia says Islamic law seeks to establish justice, eliminate prejudice, alleviate hardship. The benefits of God's law, he thinks, can be enumerated. Faith, life, family, intellect, property. Society can survive, individuals can survive, if faith and life, family and intellect and property survive. Forbidden behaviors are ones that undermine, threaten faith, life, family, intellect, and property. And approved behaviors protect religion, they protect life, they protect family well-being, they protect knowledge, they protect property. Or there are those of us who believe that the will of God can be summarized that we should love the Lord our God with all our heart, our mind, our strength, and we should love our neighbor as ourselves. And if Jesus was right in summarizing the law of Moses that way, then we can test every law of human lawmaking by the degree to which it helps us love God and love our neighbor. I'm saying that the United States, as in other countries, it's not enough to boast of the rule of law if that law merely records the terms of truce between competing interests. It's not enough to be able to say to taxpayers and litigants and property holders, sorry, they had the votes, this is the law This is the will of the majority, like it or lump it. We want to be assured that this law is in line with the full will of the one who has perfect wisdom, final authority, and perfect love. I'm suggesting that it may be hard for us to agree on the sources of our religious law, but in the process of working in our own workshops, in the process of going deep down the mine shaft of Christian ethics, Sunnah and Fiqh, we've come on nuggets that could be useful to civil law. In the principles that judges cite in civil law, the best interest of the child, justice delayed is justice denied. They've come on those principles of law somewhere in their work. And I want to suggest that even if those judges and jurists in the civil realm might be horrified to be called legal theologians, I think they've been doing a kind of theological work to come up with the best interest of the child. Justice denied, delayed is justice denied. Those of us who honor the religious law have been laboring deep in the quarries and the mine shafts, and we have come up with our own pithy principles. If we have any out of our respective searching of the religious law, why don't we take them into the public square? I know that the Alabama State Supreme Court judge tried to put the Ten Commandments on a granite stele, and that was ruled not the way to do it by the United States Court. That was too clumsy. But nuggets, principles, aphorisms that come out of our religious traditions seem to me a language that civil law does depend on. They call them principles. And I don't see why old truth from our ancient traditions, expressed in new words, pithy words, gleaming words, why can't, on a place like 16th Street, theologians of religious law and theologians of the civil law trade nuggets with each other? I know the public square is a noisy place. A lot of people want to address the citizens and the decision makers in the public square as if we were an atomized population of nothing but rational seekers of self-interest. But Christian and Muslim theologians of law have something better to offer. Our speech will never simply be for the interests of me and mine. Our appeal will be for the honor of God, who has better purposes than we can imagine for the law of the land. Thank you.